Good afternoon, everyone. A very warm welcome to you all for today's webinar on Understanding Privacy Protection and Digital Personal Data Protection Act, DPDPA. We are glad to have such a diverse group of professionals joining us, and we truly appreciate your participation in this webinar. I am Saurabh Kurdarkar, and I'm managing training operations for Quality Austria Central Asia. Just to brief about our organization. QSEA has successfully completed a decade in delivering quality services with a workforce of around 3,200 employees and a strong client base of 2,100. Also, with 26 offices across India, QSEA is a leading service provider in certification, inspection, testing, training, cybersecurity, and sustainability. We hold multiple accreditations, including NABCB, QCI, IRCA, and ISO 17020. Additionally, we have our own labs for code testing, material testing, and a cyber lab. QSEA is a leading service provider in telecom, automotive, built environment, manufacturing, government, and petrochemicals and coal industries. Just before we proceed, I would like to have a few quick notes for the learners. This webinar will run approximately for 1 hour, including the time for Q&A. If you have any questions during the session, please feel free to drop them in the chat box, and or we have created a separate tab for Q&A, and we'll address them at the end of the session. Currently, you all won't be able to unmute yourselves. We will allow you to unmute once the session is over and opened for Q&A. Just a kind request to all the participants to keep their cameras on during the webinar. This will help create a more engaging environment and allowing a better connect. So just a sincere request. So you can on your cameras, please. Thank you. So now it's my pleasure to introduce our faculty for today's session, Colonel Sunil Kapila, sir. He's a seasoned expert with an illustrious 35 years career spanning with esteemed organizations like Tata Advanced Systems, Wipro Technologies, and he has also worked in defense, research and development, and military operations. With a unique blend of technical expertise and leadership acumen, Colonel Kapila sir brings an extensive expertise in cybersecurity design and system audits, robotic process automation, privacy consulting, that is GDPR and DPDPA. His impressive background and expertise make him an exceptional resource for organizations seeking innovative solutions and strategic guidance. So further, I would like to hand over the session to Sunil sir. Sunil sir, good afternoon.
Good afternoon, Saurabh. Thank you for a kind introduction. I hope I'm audible to
yes, sir, audible.
Guest and audience, and indeed it's a pleasure to welcome, and I will take you through next 1 hour, hopefully engage you well with certain critical issues which pertain and trouble us and our organizations based on privacy and how to implement some of them and how do we map it, what are the tenets of the DPDA Acts and how we can go about preparing ourselves to ensure that we are compliant. So that's what the topic also says, as already introduced. So before we begin, in the very beginning, we will also, while we go through the topic today, we will go through why is it so important to protect personal information. We have already hitherto aware of protecting confidential, sensitive information about organizations, but privacy pertains to personal information of the data principles, as the DPDA calls them, or it could be individuals or PII, which we call in some of the legislation that, in CCPA, particularly in GDPR and US. Why is it important? Because for the very fact reason that consumers who deal with us or all services want to be very sure that their personal information which they are sharing for soliciting services from us are only used for that purposes and that purposes alone. And that is where these regulations like GDPR, CCPA, and so many other cyber laws are being governed now and have become a law, including now in India. Consequences, we are all aware in the news. I don't want to take through detailed sessions or case studies where you find large amount of data has been breached, personal identity has been compromised, which has led to further privacy violation. That in turn will lead to cyber threat, cyber harm, and financial implications, which has become a norm of one of the cyber criminals or even state vectors. So, as we digitize, as we are transforming our business, all the more important it is that we not only look at how to make our system secure and robust, but also the information and users who are using these digital platforms, their personal information has been privacy has been protected in a big way. As we go along, we will also study some of the principles, some of the important principles in data privacy, and then how do we mitigate and meet these challenges. So it's always good to start with a small definition. This is not a formal definition, but very simply put in a layman's language, privacy is the right to solitude. I just want to be left alone, to put it colloquially. That is the fundamental distance of privacy when it started as human rights charter, which said that I have the right to my privacy, I have the right to be left alone if I don't want to be engaged. So when you're talking in the digital sense, then when we start using this information, it is upon me, it is my fundamental right or the individual's right to choose what information he wants to share about him or herself and with whom and for what purpose. So already you see very simply all these laws and regulations are going around these fundamental, very simple principles which tell us what are the best practices, and now it is incumbent as law to handle personal information which is gathered, utilized, how to guard it, and ensure that it is only used for the purpose for which it was shared and not for any unauthorized usage or intrusion. So that in turn is the data privacy we're talking about. Because when we are talking of digital world, all personal information is all being translated and transformed into digital data, digital asset. So a larger context of data governance becomes very important. And while that becomes important, we ensure that privacy and data uh, security is also managed through these fundamental principles. It depends upon the organization we are dealing with. If you are an organization which giving the services and selling services across the board, across the globe, as we are all an interconnected society, we need to be very sure in the geographies and the citizens what are the laws prevailing in that region, and we should not end up violating any of the data privacy regulation laws, because there are very hefty prizes and fines which are enforced by the data protection boards across the EU, across the US now, and many other nationalities, including India. These points is also telling you freedom of thought and expression, emotional well-being, and why privacy is so important, because it protects you from harm. If unauthorized, unintended information is shared in the larger public, which was not intended to, it can bring personal, physical harm to the data principles or to the individual, and thus it shows in building trust between individuals, trust between organizations, trust between the individual to the organization, which the individual wants to feel very safe, that whatever information and services is soliciting from us or for anybody, his personal information is being handled with care, with due controls. And some of the, as we go along, I will tell you some of the controls which become very, very important as far as the privacy is concerned. And of course, if this is ensured, then people will start using the latest technologies, the automation, the RPAs, machine learning, AI, without which no transformative, innovative solutions are being worked out. And in the context of AI and machine learning, all the more important it is that inadvertently no biasing of data, uh, no targeting of very specific ethnic communities or any other things, all are covered under the incumbents of data protection and data privacy. And that is why all the more as we are going and advancing into AI, machine learning solutions, it is becoming very, very core. Privacy and cybersecurity are two sides of the same coin, which has to be considered as we go along in building up these solutions. So very specific, if we were to break it down into very specific formal phases, you can say these are some 5 phases phases of privacy protection which we need to consider in phase wise, what are the activities we do in those phases, and what would be the outcomes of these which we put together. So when we start doing initial assessment of an organization, be it from building up a new solution, offering a new service, building up a new business vertical, or even carrying out good old audit and privacy protection assessment, preparing yourself to be compliant to the regulations, we have to carry out people, processes, security, and data become some of the activities we do. We are also doing, you might ask the question that these are also done into ISO 27001 and other regulations which we are already familiar with. But you will understand that these were handling wider protection of the data of the enterprises. The individual or the personal was not central to these regulations. With GDPR, with the DPDA, individual becomes the centerpiece of the regulation. So protecting and maintaining privacy and protecting his data is becoming the core foundation principle of these laws. So that is big change in the mindset, in the way we look at data protection. So we need to carry out assessment. When we do things, we have to do mapping of data. We need to do data flows. And these are some of the activities when we do implementation, when we do gap assessment for privacy protection. And these are some of the core areas and services which we do largely in cybersecurity and Quality Austria. And me personally have been doing GDPR and DPDA consulting for the last 3 or 4 years. And I'm very happy to share with you that we have within our premises here in the NCR region of India, a good lab with all these artifacts built together, simulated labs, case studies, wherein we build up automation scripts and solution to ensure that we are able to give services which are compliant to the client may want. And also keeps our team totally aligned to all the changing landscapes and lot of the new challenges because of the immersion or adaptation of technologies like AI is resulting. So we also have to keep pace with how do we manage biases of, for example, data models which are used in machine learnings. If there are data models are biased, are skewed, then how do we detect, that these data models are skewed, and thus brings in the thing of bringing in controls, requisite controls to be implemented for privacy protection. So this is one of the assessment phases when we do one, like we used to do what is called privacy impact assessment. This is one of the very core activities which we have to do when we do privacy protection. We look at the process, we look at the flows, we look at the people, we look at the business context, break it down into the impact it has on the privacy of the individuals who are either using, who are data stewards, who are consumers of this service, or even who are operating with these services, or whose services or whose data is being churned and pushed through the data pipelines of that service. Right. For example, if you're taking a telecom service provider, your data, your personal KYC, your data is all available with them. Your SSNA in India, what we call the Aadhaar card data, your personal data, and linked with you, your personal artifacts of your families are also get impacted. So that is the assessment phase. Most important, one of the core activities we do in the assessment phase is privacy impact assessment. This is something which tells us where we are, what we need to do, and how it is, where all data are flowing, and where all we need to put our focus on. Then we go about building up, given the business context, what is the design phase? How do we implement privacy protection? How do we build up PRA, what is called privacy risk assessments? What do we kind of controls we put? Any changes to the processes we need to do is something which we build up on this. And then there are certain artifacts. And for your benefit, I've just given a small snippet. As we go along, I'll share with you one of the biggest problems when we begin this activity and implementation of privacy is to discover private data. I mean, search your heart, and if we are a large organization, one of the biggest challenges when we do implementation is to discover where all personal data is lying, because it's all spread in all over your databases, your transaction systems, your cloud, your servers, your endpoints, your shadow, cloud storages, your personal OneDrives and stuff like that. And there may be a lot of personal data, not only about you, but your client whose services you are managing. So we need to discover that. We need to look at the infrastructure, IT infrastructure, the log file, the system support, the SNMM management systems. So it's a huge problem. And then on top of that, for a very large organization, if you have implementation of Oracle databases or SAPs, one of the biggest challenges is, since they're all, these systems are spread across the globe, across the continent, how do we ensure where all personal data is lying and to detect it? So one of the serious problems when we go into implementation of privacy is to first do PIA or personal data discovery of the information. In large organization and the volume of data, personal data we are handling is just not possible unless you're talking about a very small SME enterprises where you may be able to manage these small data through an Excel sheet, spreadsheet, but just not possible in enterprise systems to be able to manage this information and create these repositories of personal data. And more importantly, when we deal with privacy, it is not only like an IT infrastructure repository which we need to maintain, we need to maintain a data map. We need to know is data in motion. And data in motion means personal data in motion. That means it touches various stewards, people, operators on the thing, who all touch that data, who all deal with data, how do they handle it, how do they store it, how is it kept, need to know basis, how is the sensitive data protected from people who do ITL or services support to your system. So all this is part of the privacy management and security management. We may be transporting data, storing them, archiving them, transforming them, process enhancement, sharing them with our customers, supply chain. That is called also. In that, we have to ensure that if any personal sensitive data which is marked and labeled as personal data are reasonably protected through controls. Legislative control, MOU-based controls are not good enough. I mean, they pertain to the law, but finally, as technocrats, as digital data stewards, we have to put the requisite technical controls also in place. So it is TTPs, as they call it, tactics, techniques, and procedures. All three bundled together ensure that we have a proper transformation, management of the data, and when it changes its form, we are still able to track it and know where is all data flowing, how is it flowing, and then there are things. If we don't do that, there are chances of danger of you losing sight of your data pipelines, your personal data pipelines, to be very specific, within the larger data pipeline, and then breaches may happen unknowns to you. And then you will be discovered, sadly, we will discover sadly that data has been breached and available in the public with data brokers, and your personal data and is sold. One question you may be asking, why is there so much hullabaloo of data? Because personal data is now a gold mine. It's like the new oil, they say, in the parlance of data analytics, machine learning, because the digital economy thrives on information and data. And all personal data can be not only used, it can be misused to bring harms if it is going in the wrong hands, uh, right? So how do we operate it? What are the rights? Then the legal angle, the legal privacy lawyers come in and say that what are the rights we have to give to the data principal. If I have certain rights to be able to say deny certain services to somebody, or a consent has to be taken from me, which can be called the operational framework under which we operate privacy protection. As you know, there are standards like ISO 27001. It has been transformed very recently, and the data privacy, personal data, which were extracted out of the clauses from GDPR, has been embedded into ISO itself, and that standard is now being called 27701. So when you are going for a 27001 standard, incumbent within it is by default, you are ensuring that you are getting data privacy protection also if you are totally compliant to those standards. On the other
So the
hand, if
slide
you're
is not changing, sir. The slide is same. We are there on the 5 phases of privacy.
yeah, I'm phases, I'm still talking through that only.
Okay, okay, fine. Thanks.
I'm on the operating stage, if you're following what I'm saying. Yeah, so the last stage is, these are the operating stage. The last stage is the compliance, adherence to that, audit report, how do we monitor? One of the things of conformance is how do we ensure that privacy is being maintained like any other cycle, Deming cycle or any other cycle. After having implemented all these controls in place for privacy, we have to continuously monitor and keep reporting if any breaches are happening, if any compliance is happening. So if you really see, this slide is why we spend more time on this, because this carries the whole gambit of the privacy protection, right? Now you say, okay, we've been talking about private data, but what is private data? What do you classify as private data? Well, some of the examples, uh, personal data is something where an individual can be identified, or any data in relation to him uh, which can be classified as personal data. Example being his address, his IP address, home address, date of birth, phone numbers, credit card, Aadhaar card, passport, and even cookie IDs. Your browser, if you are using a standard browser, if it has a fingerprint and it is on a fixed IP address, that also data, if it can identify me, who's the guy who's sitting behind this browser, then that also comes under the gambit of personal data. So it's not only biological direct identifiers, personal identifiers, which identify us, but or also this indirect identifier which identify or identity is also classified as private data, right? So why, in which all areas you may say, why does it concern me? I am in healthcare, for example. Most important, you are handling in healthcare, if you are a physician, doctor, or staff managing the health services or even mobile services, diagnostic centers, you are dealing with very sensitive personal data of the citizens, right? So very, very important privacy data issues are very, very predominantly very, very important, right? Financial data is always, even otherwise, now it's even becoming more and more because through the loss and leakage and breaches of personal, private financial data, financial frauds are being perpetuated and a lot of financial harm is happening to the citizen. Biometrics, genetic material, uh, segregating, you're going through clinical trials, your biological traits, all are becoming important through which your data can be body scanners at airports. All these are becoming areas where data privacy is becoming paramount importance, and we have to ensure that whatever controls of security or surveillance controls we are putting, the private information is being properly handled. And we'll see some of the example, how do we ensure and de-identifying what is called, how do we de-identify the data or how do we mask this data becomes very important so that the personal identity of those individuals is not compromised. For example, full body scanners, you will not want, while I am being scanned through full body scanner at airport, my data should be used and known to anybody other than the authorities who need to carry out border control or passport control, right? And where are the data being stored, how is it being stored are becoming very, very important by data privacy control. Your geographical records, because through you, where do you reside, indirectly identifies you, that it is you we are talking about. Through that, then ethnicity, racial discrimination, unfairness practices in business. If you are being targeted unfairly, automatic, what do you call, grouping is done based on ethnicity, biometric data. It can lead to privacy concerns. So these are some of the important issues and why it is becoming very, very important. Till now, we have never worried about it. Social media platforms are even much more important where data privacy are some of the vehicles where personal data is being very predominantly being leaked. And sometimes unknowingness to us, we are leaking it without understanding the consequences of leaking uh, our own, helping people get access to our private, personal, sensitive data. So if this is what is very understood, why is it so important? Unauthorized access can happen, people can bring harm to us, disclosure can lead to anything. For example, if I'm suffering from some biological disease, I don't know, want the whole world to know just because I went for a medical test with the hospital. I will not want the whole world or anybody else to know what I am suffering from, because it is prejudicial to my job, it may be prejudicial to my place in the society and stuff like that, and it violates my fundamental right? So these are some of the important why data protection is becoming one of the very important factor when you're handling digital assets. So similar to security concerns, privacy concerns are also weak password, access control. So you will see there is an overlap. That's why I call it, two sides of the same coin, right? So you should not diverse privacy from cyber security or security anymore. But at the same time, they are not the same, they are different, right? By encrypting data, we used to have earlier have a thing, oh sir, I've encrypted everything, we're using SSL, so nothing is read, it's all dark data. But then, you need to also carry out transactions. you need to encrypt your data in many places. Cloud, for example, if you have to carry out a transaction from endpoint to a cloud, it may go as an encrypted dark tunnel, but there it has to be encrypted because a transaction has to be done on your name. So many encryptions and decryptions happen in that life cycle. So we need to know where all. We have to ensure that there are no leakages happening, no data violation and breaches happening, no misuse happening, no denial of service, no insider threats. And as we are going forward, there are so many emerging threats which are occurring day to day through very advanced attacks, what are called ATPs, where privacy security concerns are becoming very important. So security of privacy data is also very important. Already covered, given you some example, be it your geography location, be it your basic information, government identification, your tax returns, your SSN, your personal IDs, your personal sensitive data, and financial data, of course, has always been important because you know very common what are the associated risks with it. Here is what I was telling you. Now, you may say, what are the biggest problems? I said, and you can understand, visualize it very simply. In large organizations, hey, you don't even know where all personal data is. And we have found that during privacy impact assessment, when we engage with organizations, we find even they had discovered themselves, oh, we didn't know we are saving this data here. Oh, we never thought this way. So it's very, very important to carry out data stewards now. Like we have cybersecurity individuals in any organization, it is becoming, a DPO is becoming almost mandatory, whether internal or external. DPO services are on the offer, which we also, people solicit those kind of services from us who don't want to invest in insiders for that. Now here is the example I gave you very simply. This is a homemade kind of a automation tool, which is where you can automatically from an enterprise scrap the data, collect data from all the sources, potential sources, and detect the PII. We pick up the data, we carry out our scripting, we do scripting through tools like regex, which is regular patterns, where we can identify what are the emails, what are the personal names, what are what are classified and labeled as personal data, and can't be done manual anymore. So we use these kind of a scripting tools, which is called privacy protection tools, detection. And then what do we do with it? We either detect it by masking out the sensitive names so that the information is there for you to handle, but you are not disclosing the individual ID or the name or the individual identity of that individual. Very, very prevalent in the medical field where, you know, doctor-patient information is all recorded, every transaction, right? They are transcribed, and then you have to keep as a regulation, keep this data transaction, because otherwise, lawsuits and all that on malpractices are prevented. But how do you protect the identity of the doctor? How do you protect the identity of the patient? Are some of the big services where PI protection, demasking, anonymization kind of services have been asked by privacy protection people by some of our clients. And very, very application from, so what is called detecting or anonymizing by using transformers, uh, machine learning, spacey kind of tools, Pythonic scripts is something which we build this tip on. I've just given you a small demonstration. I'm not going to show you the full tool, but just an example of to give you an idea as to how it can be very easily done, and we can help you. Uh, oh, sorry, it's gone ahead. I'm trying to play it. Yeah, you can see I can select either anonymize or this. I clear it. Actually, this is under the control of the screensaver, so I'm not able to run this application. But otherwise, it's a recorded video. Are you able to play? Just a moment. Yeah, I'll now play it, right, and then go to the full screen. Yeah, you can see.
Yes, sir.
Yeah. So I'm just giving you a flavor. You see the whole data, you can't, you've got this whole mass of PDF documents, Excel, scrap data, unstructured data, the full report. Actually, I just got my medical test done a couple of weeks back. So I've just put that through this test and it's detected all my names, but it's kept all the medical parameters of my test available. So this test, if you are stored somewhere, it is decacted or anonymized, nobody can trace it back to this is my report, right? You can see this. I've detected this PIA, and then when I flag it, this is the processing auto text from a PDF, and this is the mask data because we have said anonymize. Here, you can see this. In place of date, time, value, by name, patient name comes and stuff like that. So these are some of the small automations which we are very, very, you can see this, I'm loading this again. PI output, PI input, you can put on a dashboard, we can do it, we monitor this in a regular basis, and that is the kind of things, privacy, rewards and protection people need to do. And why, you may say, why should I store all this? Why should I go through all this? Because we have to comply to the privacy controls. And why do we need to store this? Why? Because you will be asked. There are data subject rights individual has. I can ask the service who has given me service. I want to know from you what all personal data you're holding about me. You can't, I can ask to my telephone provider, please tell me what all personal data you're holding uh, about me, right? So it is incumbent by this law that they have to disclose to you within a reasonable amount of time. Okay, here, sir, this is the personal data we have. Here is the dashboard. Here thing, and for this, why we are holding it, sir? This is the consent you gave us, and we are also recorded that consent. And I have the right to say that I withdraw my consent back. I don't want to I am moving away from your service. I want to be given the guarantee that you have deleted and all my personal data from your records. And if we don't do that, we are in violation of the DPDA or the GDPR Privacy Act, right? Okay, so I think going forward, I'll get out of this demo. I thought I'll just it was instructive to tell you that how these privacy things controls are a little different from the cyber security standard controls of protection and all that. Those are also there, but these are the kind of privacy controls which we have to be placed when we deal with privacy. Okay, so I hope this much is enough as far as privacy is concerned. Very quickly, having understood the privacy, the control, and how we deal with it, we go to very through the nuances of this DPDA Act. These are for historical purposes. It became an act in 2030. It is still work in progress. Laws are being worked out, implementation are not being presently enforced, but sooner or later the organizations are gearing up and ensuring that they are complying to it, because once the data protection board in place and they start levying fines and enforcing it, that will will be not a great thing to be caught under. And this is exactly what happened in GDPR history. A lot of years and time was given to the global community to comply to their systems, to the GDPR. 2016 it became an act. There 2 years were given for it for people to transform this, and then 2018 a lot of levies and fines started being applied to the technology providers, to the companies, and everybody went scrambling to ensure that we were GDP compliant. Otherwise, you were going to lose growth, you're going to lose your business because you're no more compliant. So I think it is becoming very important. And in today's digital age, don't worry and not wait for these laws to be enacted or to enforce us to take action. We ensure that these artifacts, this control, these systems are in place as we prepare ourselves for the next digital transformation, which is already upon us, which is the AI-based systems, right? Okay, so let me move this out of the way. Yeah, so this is a small journey. It started with 2017. I think it's well known by now, most of you, how it became a bill in 2013. That was a long journey. It took through a lot of, you know, commissions were there. Supreme Court ex committee was formed that transformed into a personal data protection law, and then it became law in the July of this thing. Still, there are a lot of certifications needs to be done. Enforcement artifacts have to be worked out, uh, but it has been published in the Gazette. So sooner or later, we'll have to deal with this stuff, even from a regulatory perspective. But as I said, why wait for that? We should already be building up a system along with the security and cybersecurity protection, to put privacy into the act. And that is why the ISO came up with this new amalgamated standard called 27701, because these are just some of the historical facts which I've just shared with you. You can go through it, nothing new, what happened, what was it called earlier, and now by, by 11th August it became passed in the parliament. Okay, let's see some of the basic tenets of this. Like I said, digital personal data, rights of the individuals, and we need to process data for lawful purposes. It's not that you refuse to say, and it has 9 chapters, 44 sections. These are just some historical number figures. But here is a bird's eye view. If you just glance and spend some time through it, most important is the number 2 column, where you see the obligations of data fiduciary. Data fiduciary was called data controller in GDPR. In the DPDA Act, we are calling it data fiduciary. That means it's our responsibility when we deal with personal data of whomsoever services we give. What are the grounds? Why are we processing? Under what ground we are processing? Are we giving them enough notices? Are we taking their consent? Consent management systems are also some of the platforms which we have built up, which we are available, which we can help you build up as a content management platform, where automatically you build up a portal where people who are can log in and see their own thing and give consent or withdraw consent and things like that. So these are the kind of systems which sooner or later are going to ease the way of handling it. You can understand, with so much of data and with this become law, how many people will you employ, where all you will employ, to ensure that you are able to provide data to the citizen when they ask to, because it is their right. Rights and duties, as you can see in Act from 11 to 15. Duties of data principle. Data principle is the other name for individuals. Okay? So he can say, I want my data to be, your KYC data is not correct, please correct it. I have a grievance, you have leaked my data, or my data is inaccurate. I need to, I need to change my nominee to my, personal data. What are my duties? You know, what are the special provisions? Where all I am exempting? All this is covered. Where in under what circumstances, where it is prejudicial to the security of the nation, then there are certain special provision where you can still process personal data without taking consent, or without going through the lawful uh, implications of the thing. So all this is spelled out in this law, as it was spelled out in GDPR, which was the Bible for all the first privacy act in the world, and all other geographies who have started implementing that, they have some broad uh, framework to work on, which is the GDPR, right? Data Protection Board is established. They will tell you what are the, how its board will proceed, how they will regulate it, how they will manage it and enforce it. What are the powers they have? What are the appeals and dispute panel? And all these are covered within the Act. But very important, as enterprises, apart from the legalese point of view, is the technical data fiduciary rights, responsibility, consent, and the principle of managing data. And as I've given that in the next slide, as you can see, example, who is a data fiduciary? The guy who is responsible. For example, if I take employment with you, I am an individual, I'm a data principal, and you are handling my personal data, which I've shared with you. You are data fiduciary. You have a responsibility and obligation to me to ensure that my data, personal data, is maintained in a proper manner, and it is not used for any other purposes than for this, than for my employment with you, which you know it clearly gets violated. Ad agencies, a lot of our personal data is getting leaked, unsolicited cold calling is happening uh, under this law without the consent of the data principal. Making these calls and using that data is actually in a gray area of violating of these laws. Data processor is third parties, the people who work on behalf of the data fiduciaries, who manage the data, support systems, you know, certain financial functions are offloaded, let's say, to a third party, then they became a data processor. So the same laws, same controls are also incumbent on them of data processor also. So in GDPR, the data fiduciary was called data controller. In or DPDA Act, data fiduciary is nothing but a data controller. A change of little vocabulary there. Little graph to tell you, here is the data, we discover the data, we segregate the data, non-personal data goes not applicable for this law, but we mark and label what is personal data, which is used for domestic purposes, which will not go to the geographical or the enterprise boundary, uh, and then it is applicable. Then it's labeled, scanned, even scanned paper data, non-digital form data, which for storage purposes will be scanned and kept, also comes under the category of personal data. So let us not assume that only digital data, which is we are managing, is the personal data, and we have to protect that. We have to also ensure that if we are keeping backup data, copies, master copies, scanned documents, we are maintaining that in a proper digital vault and labeled and tagged and not used outside the confines of this law. This is the applicability. If it's personal data, yes. Proceeding in India, yes, it's applicable. If you are proceeding outside of India, but for using services of data and services of principle in India, it is still applicable. The only way this graph shows is that it is not applicable if you are not dealing with digital personal data, you are not offering any goods and services to the principal in India, then definitely this act is not applicable to you. Okay? So this is a regular cycle of starting with the collection, processing, recording, alignment, indexing, sharing, transmitting, disclosure. The complete life cycle of data processing is also very much applicable, as rightly so, to data processing. Personal data. Here when I classify data processing, I am not repeating every time personal data, but it's all pertain to personal data. Okay? Here is the two important aspects I've stated scanned out of the law. Personal data has to be processed for only lawful purposes, right? For that, we need a consent of data principle is a mandatory thing under this law. And it's only under very special thing where deemed consent under certain legislative conditions where it is deemed that since you took for this service, you applied for this, for example, if you apply for a passport, then it's deemed that you have given within this form your consent that your personal data you are sharing is used. But it will be only for that lawful purposes, and not that the passport issuing or visa pushing authorities will use that data for any other unauthorized means. That is the important point to remember. Uh, so, very important, data fiduciary provide notice to the maybe prescribed, and data principal has to be asked for consent and they give the content. So this is called announcement and permission. That means if I am going to be using your personal data, if I am the data fiduciary or data controller, it is incumbent on me to take consent from the data principal and record it and use that as the lawful basis of processing. Your consent should be free, not solicited, specific, informed, unconditional, unambiguous, in very clear language. That is why I am saying there is a whole gambit within the law and through the authorities. People have started building what is called CPM, which is the Consent Management Digital Platform within their system. It's like a personal consent management portal so that you're relieving your personal data staff to ensure that the consent is managed properly. If the content is withdrawn, then that is also recorded. And if it is when it was given, that signature, sign, terms. No more it is enough to say that we have the terms of reference and agreement and which runs into 20 pages and somewhere within that we have hidden certain the privacy laws and consents are taken. That will not do. You have to make it very specific, informed, and very, very unambiguous. By putting all these statements of consent within a very large terms of and condition document will many times not uh, will not apply. And this is where you'll find that the options for opt-in, opt-out, notice management, it becomes itself a big uh, control systems in place, right? And anytime the data principal has got it right, he can revoke his permission. He says, yeah, please, thank you very much. It was nice dealing with you. Now I'm wanting to move and take the services from some other data fiduciary. Please, I withdraw my consent which I had given earlier to you. So it debars you from actually, revoking that permission. So once that is done, you can no more use that personal data for any other purposes without the consent, even for marketing and things like that. That is where the gray area is, where many times you may err on the because we all want to grow our businesses, we all want to customer data, consumer data is a gold mine, but without consent, without lawful basis to deal with it, will be in gross violation of this Privacy Act. So these are the legitimate uses. Voluntary provided personal data by the data principal. If I am seeking employment with you, I am providing you my personal data. It is lawful. Public interest, for example, if I meet with an accident on the way and you are immediately sharing taking my personal data, asking for emergency service, rushing me to the hospital, that definitely is a legitimate use of my personal data because it's going to save my life. Or for judicial use, right? Or any state government instrument, you may use that data where they find that they need to scan that for the larger good of the society or the thing where data under the judicial uh, instrument, uh, subpoenaed, and then you can scan personal data. That will be a legitimate use. And that is also a gray area where surveillance, automatic hidden surveillance by 5i, for example, became such a big cry because citizens world over realized that their data was being stolen and their data was being stored and indiscriminate, unauthorized surveillance was being carried out on all their activities on the digital thing. So one has to be very, very careful when we use our digital footprint, how are we increasing our footprint and how are we ensuring that not only privacy and security, that's why privacy controls are in place when we use instrument of data transmission or transmission. For example, your laptop, your iPad, your digital information. You have put proper controls in place. So that is also one of the important services which we provide due to our awareness, which is we all think we know all that. So it is not about knowing the theoretical definition of privacy and privacy. It is to ensure that how are we uh, enforcing it, how are we operationalizing it, day to do use, how are we keeping our family or children or elderly at home also safe from the digital infringement or disruption, or which may be uh, we may be subjected to. So this is a data trustee, the central volume of centrality of personal data. Significant data is another definition this law has, which is not only of fiduciary, the significant data of fiduciary is based on the evaluation of the importance. That means wherever the integrity, that means you can handle very sensitive data, especially without taking the consent of the individual when all these conditions are coming to a rear. For example, risk to electoral democracy, security of the nation state itself, and restoring public order or good, right? Infringement of fundamental rights of the data principle, or we are handling automatic processing, which is becoming a very dangerous thing with AI-based system, where the scanning large volumes and automatic sensitive data scraping of personal data, and based on that, certain decisions are taking which may bring the data principle to a great harm. So those are the data uh, trustee. Significant data fiduciary has been evaluated under these conditions. Government has been given the right to, uh, not take consent of the individuals. For that also, if you are doing that, it's very, very important. These are very important that data trustee to have a data DPO. As you would have seen, data PTO services on the rise. Uh, some people who don't want to hire a DPO officer inside, they take an expert service as data protection officer as a service, right? Data protection and independent data auditor is required by the data trustee wherever you are doing significant data appointment in accordance with this law. Periodic audit has to be done of wherever this data being used, personal data being used by the data trustee. Periodic impact assessment, I told you, is one of the biggest instrument. Enterprises as well as government data inventory have to purpose go through. These are some of the things. So it brings me a very important thing which we are normally asked for when we are developing applications, when we are developing platforms and services. You need to carry out an integrated privacy risk assessment for secure development of your platform, for your micro architecture, from your digital solutions. So, like any other good thing, we do planning and scoping. We identify risks, which are privacy risks. We create data flows, label them, mask them, what is called data mapping, and then carry out risk assessment and maintain a record of it and a dashboard of it where you know what is the last thing. So this is the kind of very, very important activity. Anyone who is building up data services, data platform, software development needs to go through security by privacy by design, privacy risk assessment into their security development portfolios. Okay, so here is how we conduct it. Data mapping, inventory, these are artifacts, uh, and we will be more than glad to give you any guidance or any services to how data mapping could be done, uh, how risk identification or privacy risk I'm talking about here, how it could be documented, and how a platform of a privacy risk assessment could be done. So it basically results into three different activities. technical activities which we do, what is called privacy impact assessment, PIAs, privacy by design, integration, how do we ensure that new system which we are building, application we are building all the control, the consent management, the notices within the integration of the platform. And of course, last but not least, but often forgotten, privacy threat modeling. First, we need to model our data. What are the potential foreseeable privacy violations or threats which we suffer? So these are some of the aspects I thought, why is it important to be able to do this activity also? Proactive risk assessment. So this law also says, like cybersecurity, you cannot be sitting in a closed in a wall and thinking that I'm secured. You have to proactively identify risk all the time, compliant to either GDPR, IDPA, CCPA, depending upon what are the kind of geography or citizens you are dealing with, because it builds you health trust. And good business means good, trust me, good brand, always uh, useful for potential growth of revenue and expanse of your services, and reduce likelihood of data breaches. You know, data breaches are very, very costly. You happen penal deductions, and on top of them, eroding of your trust, like the eroding share market with which we are hearing of these days because of the trade wars. Uh, but similar kind of thing, your customer can move away from you if there is a gross lack of trust in the way you're managing their data, and a lot of data breaches may have happened. Because personally, privacy and right to the freedom is very, very important to any democratic digital citizen. Just as a glance view, I tell you, the further, if I would say it, the key principles of GDPR were lawful, fairness, transparent, purpose. We only do purposeful limitation of use of personal data. You minimize access of data, collection of data, only that much which you need, and not collect everything and then decide what all is useful for you. It should be accurate. How do we store it? And then how do we maintain its security and integrity and confidentiality? So many rights were given to the consumer and to data principle, from right to withdraw, ratify, erase, restrict, and very heavy fines have been enforced in GDPR. Similarly, I have compared on the right side, consent is very important for DPDPA, right for data principles have been again given in this. Data protection impact assessment is what they call it, DPIA. Data breach notification has to be notified to the data protection board of the breach. You cannot hide the breach, thinking that nobody will come to know if the data breach happens, that your this thing. And of course, data localization, that certain data should not, of citizens should not leave the geographical boundaries of that country. This is again the we already covered. One or two more slides. Uh, I'll reiterate, which I've covered through while we went through it. Data discovery and classification, gentlemen, is the most important thing in data governance. Then, of course, need to know basis, access control, whosoever are accessing control, how are you restricting control them, and how do you anonymizing and sensitive data are protecting from people who are handling the data as it moves in the data pipeline, right? Or what is called the ETL process even. Earlier, if you remember in data handling, we used to call it extract, transform, load, ETL process, right? And then of course data modeling, and then data processing, and then dissemination of data or storage. So everywhere lineage tracking is very important. Data is labeled, tracked, and uh, ETL type, Splunk type management tracking system is kept, so they exactly know where all your personal data, which is labeled, which is very sensitive, where all is it kept, how is it tracked, how has it been handled, and how are you ensuring that it is not violating any of the DPDA or the GDPR Act. Okay. I think one or two more slides, and first line of defense is, of course, like anything, uh, take minimum data, grant only access to those data who need to really know it. Then you apply your anonymization controls, your detracting controls wherever sensitive data is being handled to ensure that privacy is not violated. Now, one should not take it lightly with a grip of salt that, yeah, fine, how is it important? I am not holding anything which is important. Many of us have that view. But remember here, the central theme is the data individual. You are incumbent by this law. It's a dutiful fiduciary duty of the controller and to the data processor to ensure that privacy of the data principle is not being violated. We are presently on a ratio of 1 is to 10. I wouldn't like to give a figure to it, but we are not very, very conscious and sensitive towards it. But sooner or later, it is better for our own good, or for the good of our own organization, that we as individuals ensure that we are safeguarding our personal data from the other data fiduciaries. And when we are handling other citizens' personal data, we ensure that we are handling it with care and need to know basis, uh, and do minimum. What you don't know, you can't, violate. So only come to know, need to know basis is very good principle we used to apply in the military. I think it's very, very useful to apply it in the privacy control. So gentlemen, I hope I've been able to convey to you, sorry, gentlemen and ladies, if there are any out there, I'm not aware, but this brings me to the end of today's session. If there are any questions you will like me to address, something you feel uh, you want to engage with us, or trainer is there in sync with you, feel free to right away ask questions now if the time permits, or you can drop in mails to or trainer. We will definitely get back to you in no time. And if there are any services you solicit from us for GDPR, DPA, privacy protection, automation of these controls, we'll be very, very glad, me and my team, to offer you the best services available which might meet your need.
Yes, participants, you are now allowed to unmute. So if you have any questions, you can unmute yourself and ask, please. You would be now able to unmute yourself. I think so, Mr. Ramesh, you had some question, right? There was one in the chat window, sir. Mr. Ramesh has asked for action item. I mean, carry out assessment and mapping for data flows for privacy protection.
Yeah. What about it? What is the question? Yeah, of course. Very, very important. Like I said before, data mapping is very, very important activity and very much part of the privacy impact assessment which we do initially, and then formally when we do DPDA, if we do a new service launch or thing like that. So we don't have to just keep a data repository like we have a IT asset repository. Here we have to have a repository of data flows because data is in motion, and you need to not only know what the data is, label the privacy and classify it as either it's a normal previous personal data or sensitive data, because the sensitive data has to be handled in a much special way with special controls. So all that has to be labeled, classified, and along the lifeline, along the life cycle, sorry, always the life cycle. And who all have access to it, what are they doing with it, where is it being stored, how is it being transformed, who is transforming it, what are the keys being used for uh, uh, anonymizing it or de-anonymizing it and stuff like that. So there are artifacts uh, which we build up in platform where we carry out through this privacy. That I told you about the PRA, privacy risk assessment, data mapping will form within incumbent within the artifacts which we build there. These are not just processes, theories. Gentlemen, please understand, like I told you, CPM, consent management platform, right management platform. I showed you the discovery, PI discovery systems are in place. Uh, uh, then you also have to keep a dashboard of privacy violations or and the communication cycles. You've got to keep your communication to your privacy officer available to your client or to the data principals. So who should they contact? I mean, everybody needs to know for reporting any privacy breach or reporting any concerns, how do they reach the organization, how do they access their personal data. So that is all the artifacts which are built up. So you will realize that data mapping is one of the core activities during analysis and assessment, which helps us design these systems. And auditors, as auditors of GDPR, I used to be doing an implementer and auditor of GDPR. This is one of the first things, along with the risk register, which the auditors used to look at. Okay, data, where is your data map? Who all are having access? What all data are there? Have you labeled it properly? Have you not? Where is that data map? That is also handling personal data. Why is it not inside your management or a control system? So those are some of the things which privacy protection stewards and auditors or DPOs will look at.
Fine. Thanks, participants, for the time you took to join us today for this webinar. We hope you found the session informative and valuable. Before we close, I would just like to thank our faculty, Colonel Sunil Kapila sir, for sharing his expertise on this subject. So further, if you have any questions, participants need any clarification on any topics what we discussed, please don't hesitate to reach out to us. Thank you once again, and we look forward to having you and join us for future sessions. Goodbye and
Thank you,
thank
Gaurav.
you.
It's
Yeah,
always a
thank you.
pleasure to able to share our expertise we have with you and your client.
Okay, thank you. Thank you, sir. Thank you, participants.